Thank you very much to the organizer, and thank you very much to my old friend Paolo Pinto del Buquerque for inviting me to this thought-provoking Congress. In my intervention, I'd like to share something from my specific experience as an Italian and as a member of a constitutional court, an institution which is not, from a technical point of view, a part of the judiciary, but is generally perceived as such and has the task to step in when necessary to protect the rule of law and, of course, the independence of judges. To this aim, please allow me to shift a little bit the focus of our reflection to a topic which was hardly touched upon yesterday, namely the interconnection between judicial independence and public confidence in the judiciary. As I'll try to show, the Italian situation vividly illustrates how vital is this connection. From both the jure and de facto perspective, the Italian courts and the Italian prosecutors as well enjoy a very high degree of independence from any other power of the state, indeed in a degree which has few comparison in a comparative perspective. Yet, the judiciary as a whole is experiencing in my country possibly the worst crisis of confidence in the public opinion since the birth of the Republic in 1946. And this climate may well create the conditions for legislative reforms undermining the judicial independence itself and ultimately the rule of law, as the experiences we have examined yesterday have vividly shown. So I will divide my presentation in three main parts. In the first part, I will say some words on the situation of judicial independence in Italy from an objective perspective. Then I will try to briefly analyze the causes of the confidence crisis in the judiciary I have just mentioned. And finally, I will reflect on some possible strategies to overcome this crisis and avoid thereby the scenarios we have witnesses in other European states, drawing some suggestions from the recent experience of my constitutional court itself. So, as to the first point, the situation of judicial independence in Italy, I think it is fair to recognize that not only judges but also public prosecutors enjoy in Italy a very high level of de jure and de facto independence from any political powers. The principle of independence of the judiciary from any other power is enshrined in Article 104 of the Constitution. According to other provisions of the Constitution, appointments, promotions, and disciplinary proceedings for judges fall under the exclusive competence of the High Council of the Judiciary, which is composed on its part for two-thirds of judges and only for one-third of members elected by Parliament. The internal independence is guaranteed by Article 101, according to which judges are subject only to the law. According to other provisions, judicial appointments are based on public competitive examinations. Once elected, a judge may not be removed from office unless by the decision of the High Council itself at the outcome of a disciplinary proceeding in which the person concerned fully enjoys their defense rights, the decision itself being then subjected to subsequent judicial review before the Court of Cassation. And public prosecutors enjoy the same constitutional status as judges and are indeed subject to the authority of the same High Council. But the actual performances of judges and public prosecutors in Italy confirm, I think, the high degree of independence which is granted de jure by the Constitution. At least since the beginning of the 90s, a conspicuous number of prosecutions involving members of parliament and prominent government officials, including a prime minister in office, have taken place in Italy. And many of them have actually led to convictions, sometimes with the effect of banning the individuals concerned from holding public offices for a certain period of time. Even more remarkably, my country has been the first where an investigation launched by a local public prosecution office has led to the conviction of various US intelligence agents for their involvement in the extraordinary renditions program coordinated by the US administration in the aftermath of 9/11. And this conviction has been particularly meaningful since the investigation was carried out without any cooperation by government agencies, which has indeed refused to give any information to the prosecutors on the ground of state secret. And you know the case, of course. Yet, as anticipated, and I'm coming to the second point of my presentation, the overall picture in my country is far from ideal due to the very serious crisis of public confidence in the judiciary I have just mentioned, which risks, in my opinion, undermining the perception in the public opinion of the importance of the very principle of judicial independence in a democracy. The recent experiences of attacks against judicial independence in other member states of the EU, carried out by governments and parliaments freely chosen through democratic elections, is actually a ominous sign. In those states, public opinion has hardly reacted against such attacks, either because of a lack of understanding of the key role of judicial independence for the rule of law and democracy, or more probably because of a general lack of trust in the judicial systems in the same countries. A reaction came too late, mostly by international organizations rather than by national actors, apart, of course, the judicial actors directly involved. It is not by chance that since a very long time the European Court for Human Rights has been stressing that justice must not only be done, it must also be seen to be done. The appearance of impartiality of the judiciary is just as important as its being impartial and independent from any other power. And it's not by chance either that the Council of Europe's plan of action on strengthening judicial independence and impartiality, adopted by the Committee of Ministers in 2016, in its very introductory words stresses that it is, I quote, of primordial importance that judicial independence and impartiality exist in fact and is secured by law, and that public confidence in the judiciary, where it has been lost, is restored and maintained, end of the quote. The two aims are inextricably linked. A lack of public confidence in the judiciary is not an Italian prerogative, admittedly. Judges and prosecutors are often seen by sectors of the public opinion throughout the world as part of those elites towards which a generic feeling of resentment is rising. But the Italian situation is particularly worrying for several reasons. First of all, the functioning of the Italian judicial system has always been suffering from the excessive length of the proceedings in almost every sector of the law. There are, of course, good reasons to argue that Italian judges and prosecutors are hardly responsible for that. The causes mainly lie both in the complexity of the procedures envisaged by law and in the excessive number of cases which need to be dealt with that no legislative reform has been able to reduce so far. But the fact remains that Italian courts, in spite of the strong personal commitment of their members and their widely recognized high professional skills, are incapable to render justice within a reasonable time. And this is inevitably perceived by the public opinion as a failure to render justice at all. Secondly, the very strengths of the Italian judiciary in terms of strong independence from political powers, in particular the abundance of indictments and convictions concerning politicians, often give rise to accusations towards courts and prosecutorial offices to pursue themselves political agendas, a fact that contributes to undermine the moral authority of the judiciary, seen as a partial actor in the political arena. While similar accusations are common everywhere in the world and are to some extent inevitable in such cases, the criticism is probably less groundless in the light of the gap in the recent Italian experience between the great quantity of investigations and prosecutions involving politicians and the smaller number of final convictions, as the very opening of an investigation and more still a prosecution already damages the political life of the person concerned, even if he or she is eventually acquitted. And finally, recent judicial investigations and the following scandals have shown a disturbing net of improper connections between some politicians and some members of the High Council of the Judiciary with the aim of controlling or at least influencing the appointment of judges and prosecutors in senior positions, a fact which has strengthened in the public opinion the impression of partisanship of the judiciary against the background of a long-standing and highly criticized practice that gives a key role in the decision-making process of the High Council itself to the various judicial associations representing judges and prosecutors, which are often perceived as improper political factions within the judiciary. All these factors, of course, do not undermine the factual independence of judges and prosecutors, which keeps being one of the strongest in a comparative perspective, but certainly weaken the moral authority of the judiciary as a whole in public eyes and risk undermining the acceptance of their decisions, which could also lead in a long or mid-term perspective to possible refusals to comply with those decisions by the political institutions. As Professor De Wert has reminded us yesterday, the judiciary is the least dangerous branch of the state, having no sword nor purse to enforce their decisions, which are to be respected simply on the ground of the legal and ultimately moral authority of the institutions that have made them. How could then public confidence in the judiciary be rebuilt in such a scenario? And I come to my final point. Well, let me start by the general suggestion contained in the Council of Europe's Plan of Action of 2016. The judiciary itself should adopt, I quote, a proactive approach towards the media and to the dissemination of general information, end of the quote. Transparency and communication appear to be at the core of this recommendation. Preservation of judicial independence cannot sensibly mean lack of accountability. Courts and prosecutors do not certainly need electoral support, at least in Europe, but they do need to enjoy trust among the public, and trust can't be taken for granted. Because trust must be acquired and maintained through an ongoing dialogue with the public by showing what is the proper function of the judiciary and how this function is actually carried out. These observations seem to be obvious, but unfortunately they are not. At least in Italy, judges, even constitutional judges perhaps, tend to think that, unlike politicians of all sorts, they should perform their duties in silence, speaking only through their formal judgments. But the problem is, of course, that judgments, even if they are available in the internet, as it is the case of judgments of the constitutional courts, are often too long, too technical, too complicated to be read and understood by anyone without a legal background. This is why my constitutional court has felt a compelling need in recent years to adopt a proactive approach towards the media and the public in general, as suggested by the mentioned plan of action. Just as other supreme constitutional and international courts, we have started to publish press releases on our most important decisions in a language that can easily be understood by the general public, summarizing in plain terms the core of the judgment, its holding, but also the essential reasons supporting it. And our experience shows that newspapers and in general media reports generally reproduce the press release itself, thereby granting a correct communication to the public on the content of the judgment, which of course doesn't rule out the possibility that the judgment is criticized, but at least ensures that the critique is not itself based on a misunderstanding of the judgment. Beyond the communication concerning single judgments, we have also thought it was necessary to improve the knowledge of our court and its vital function in a constitutional democracy. And to the same, we decided to put in place a multifaceted strategy which includes, apart the well-established internet website with all the relevant information about the court and the judgment, a Twitter and an Instagram account and various series of podcasts recorded by judges, sometimes in dialogue with prominent public figures, explaining in simple terms what the court does and what is the court's jurisprudence on sensitive matters. In the pre-COVID era, we also engaged in lectures throughout secondary schools, as well in a tour through several Italian penitentiaries, which was documented in a film produced by the Italian TV broadcast and later shown in schools and public events. A similar communication policy could probably be performed by the judiciary as a whole, including public prosecutions. The strategy could be, of course, differently shaped according to the different size and financial means of each judicial institution, but its aim should remain that of sharing the essential information about what the judiciary does in its day-to-day activity to the service of the public. In the absence of a proactive communication by the courts, the pieces of judicial news that tend to be published by the media are precisely those damaging the reputation of the judiciary. Isolated episodes of judicial corruption, improper links between judges and politicians, systemic failures in the handling of the caseload, etc. A counter-narrative is therefore needed to show the many strengths of our judicial systems and its vital role to preserve the rule of law, the people's rights, and the basic conditions of our social life. A specific effort must be employed, in my view, in explaining why it is so important that this role is performed by actors that are independent from any other power and don't directly respond to the electorate for their performance. This last point seeming indeed counterintuitive and being perhaps the most difficult to explain to a lay person. I vividly remember when a good friend of mine, a well-educated person working as a manager in an important firm, candidly confessed to me that he could not understand why on earth judges and prosecutors should not be democratically elected like any other person holding a power, as it happens, by the way, in the majority of the US jurisdictions. What is so obvious for all of us is not necessarily such for our fellow citizens. And we should explain to them why it is important that the situation is not like in the US jurisdictions. Communication, transparency, and ultimately accountability should in sum be our key words. Flaws, shortcomings, systemic failures should not be denied. They should instead be fairly acknowledged, alongside with the expression of concrete commitments to fix them in the framework of realistic strategies and according to reasonable timetables. At the same time, the positive results in tackling the caseload, in granting prompt responses to judicial challenges, in ensuring protection to neglected rights, or in bringing to justice criminals as far as public prosecutors are concerned, should be properly highlighted in a sober but self-confident way. Judgments themselves need to be explained to the public, explained when they concern matters that have attracted attention in the media, such as in the case involving prominent public figures and politicians. The reasons why, for example, a member of the government is convicted or instead is acquitted after being indicted of a serious crime by the public prosecution deserve to be communicated in clear and well-balanced terms, since the community who has elected her has every right to know why she's stripped from their office by the decision of a non-elected court, or is finally declared innocent after being sent to trial by a prosecutor who has been not elected either. A communication service or an especially trained spokesperson, as suggested again by the Council of Europe's Plan of Action, could be in the best position to perform such a delicate task, which requires the capacity at the same time to understand the technicalities of a judgment, to extract its core reasoning, and to explain it in an easily understandable way, something which might appear difficult for trained jurists, but it is in the end so much in line with the fundamental idea expressed one by Lord Donaldson, that the law is nothing else than common sense under a wig. Communication may not be the magic solution for the crisis of trust toward the judiciary that is so dangerous for the judicial independence and for the rule of law itself. The actual problems that afflict the judiciary in Italy and elsewhere must also be tackled through appropriate and courageous strategies. But an effective communication policy is surely a necessary step to be undertaken by judges and prosecutors in Europe without any further delay. Thank you very much for your attention.